3 million pages of evidence, thousands of unsealed flight logs, millions of data points, names, themes, and timelines connected. You are listening to the Epstein Files, the world's first AI-native investigation into the case that traditional journalism simply could not handle.
Welcome back to the Epstein Files. Last time we walked through how the first Epstein prosecution collapsed at the state level when Barry Krischer reduced the charges to a single count despite dozens of identified victims. Today, we are following the case into the federal system and into the hands of Alexander Acosta, the U.S. attorney who turned a 53-page draft indictment into a non-prosecution agreement. As always, every document and source we reference is available at epsteinfiles.fm. So, the Bradley Edwards Statement of Facts, Exhibit C, lays out what Palm Beach police handed the federal government independently corroborating victim statements, seized computers, flight logs, and a draft indictment that included sex trafficking charges.
And that's really the pivot point of this entire story. We're moving from a local police investigation, which was, actually quite robust, into the federal system.
Right. And the mission today is to audit that specific transition. We have to answer how a case with so much evidence gets dismantled.
The very specific question. How does that evidence pile, which was referred up to the feds precisely because of its scope, result in an agreement not to prosecute?
So we're focused on that window, the time between Palm Beach PD handing off the files and Alexander Acosta signing that non-prosecution agreement, the NPA.
We are auditing the administrative process inside the U.S. Attorney's Office for the Southern District of Florida. And to do that, you have to start with what was in the file. You have to look at the inventory.
Because the official narrative that developed later, the one Acosta's team used for years, was that the case was weak.
Exactly. The justification was always, it was a weak case, it was just he said, she said, and that, they were concerned about losing a trial.
But the documents tell a different story, and that story starts with the Bradley Edwards Statement of Facts, Exhibit C. It inventories what was handed over.
It really does. And it wasn't just a handful of complaints, it was a complete operational map of a criminal enterprise.
Okay. Let's walk through that inventory. What does Exhibit C actually list?
First, you have the victim statements. And we have to be really precise about what these were. We're not talking about one or two people with a grudge.
Yep.
The police had statements from dozens of young women. And the key here, the forensic key, is the pattern.
They didn't know each other.
They did not know each other. They're from different schools, different towns, different backgrounds. And yet, their stories were almost identical.
The same details.
The same details. The recruitment method, the description of the house, the specific demands, the way they were paid. It was consistent across the board.
That's what investigators call independent corroboration. It's the opposite of a weak case.
It is. When you have unconnected witnesses telling you the exact same story, that is powerful evidence. It's not just he said, she said anymore. It's he said, they said.
But testimony can always be attacked in court. A good lawyer can try to discredit a witness.
They can. And that's why the physical evidence is arguably even more important here. Let's talk about the hardware.
The computers.
The computers. Exhibit C confirms the Palm Beach police executed a search warrant. They walked out of that mansion with computer towers, with hard drives.
And what was on them?
What the police described as a recruitment pipeline. They had names, contact information, schedules, digital proof. This wasn't a question of if it happened. The data showed how often it happened and with whom.
So you have the corroborating witnesses and you have the digital evidence.
And flight logs. Don't forget the flight logs. They showed the interstate travel, which is the hook. That's what makes it a federal case.
Right. Moving victims across state lines for sexual purposes is sex trafficking. That's the federal charge.
Which brings us to the most significant document in that transfer pile.
The draft indictment.
The 53-page draft indictment. The federal prosecutors were not starting from zero. They were handed a fully formed legal roadmap.
And I think it's important for people to understand what a 53-page draft indictment really means. This isn't just some notes on a napkin.
No, absolutely not. In the federal system, you don't get to page 53 of an indictment unless you believe you have the evidence to back up every single count. It means the investigation is mature.
And what were the charges in that draft?
Sex trafficking. Conspiracy to commit sex trafficking. It laid out the entire operation using the witness statements, the computer data, the flight logs. It was all there.
So let's just pause right there. The U.S. Attorney's Office in the Southern District of Florida receives a case file. Inside, there are dozens of corroborating victims, seized computers with recruitment data, flight logs showing interstate travel, and a pre-written 53-page indictment for sex trafficking.
That is the documented reality of the handover. And the local cops, the Palm Beach PD officers who did this work, their expectation was clear.
They thought they were handing it up the chain.
They thought they were escalating it. They believed the federal government, with its vast resources, its ability to chase leads across the country, would take that 53-page draft and, make it even stronger.
Expand the prosecution, not shrink it.
That was the logical expectation.
Yeah.
The case was being handed over for a more powerful prosecution.
And yet, from the moment that file crossed the threshold of the U.S. Attorney's Office, the case began to contract.
It immediately started to shrink. Which brings us to the other side of the equation, the opposition. You have to analyze the force being applied from the other direction.
This is where the weak case argument really falls apart for me. You have to look at who Epstein hired.
It's a fundamental piece of the audit. If you truly believe this was a minor case, then the defense team makes absolutely no sense. The resources deployed were statistically anomalous for the alleged crime.
You don't bring in a legal Death Star, as some called it, for a simple solicitation charge.
You don't. Let's just run down the roster. It's a who's who of American law.
You start with Alan Dershowitz.
Famed Harvard law professor, constitutional scholar. The guy you call for the most complex appellate cases in the country.
And he was local, but then they bring in the national heavyweights.
They do. They bring in Roy Black, a legendary Miami defense attorney famous for getting high-profile acquittals.
But then it gets even stranger. They bring in Ken Starr.
Ken Starr. That's the one that always stops me in my tracks.
The former Solicitor General of the United States, the independent counsel who investigated President Clinton.
The man who wrote the Starr Report. You have the person who literally tried to remove a sitting president from office.
Flying down to Florida to negotiate a plea deal for what the state was treating as a prostitution case.
It just doesn't compute. The legal spend, the caliber of the personnel, it's completely out of proportion. You hire Ken Starr to argue constitutional law before the Supreme Court. You do not hire him for this.
So their very presence signals that the stakes were incredibly high.
It signaled to Acosta that this was not a normal case. The firepower aimed at his office was that of a major racketeering case or a matter of national security, not a local sex crime.
And their strategy wasn't just filing motions. The record shows they took an extremely aggressive posture.
It went far beyond standard legal defense. It was what you'd call a full-spectrum campaign designed to exert pressure on the prosecutors.
We have records showing they hired private investigators.
Yes. Not just to investigate the victims, which is a fairly standard, if ugly, tactic. They hired PIs to investigate the prosecutors themselves.
Looking for leverage.
Looking for anything. Personal problems, professional misconduct, anything they could use to pressure the U.S. Attorney's Office to back down. They were targeting the institution.
And at the same time, they were running a very methodical campaign to discredit the victims.
A systematic one. Digging into their school records, their family histories, building dossier to portray them as unreliable, as troubled teens, anything to undermine their credibility if they ever took the stand.
But the real pressure point was the U.S. Attorney's Office itself. The documented correspondence shows a level of access for Epstein's team that was unusual.
Highly unusual.
Mm-hmm.
You have these top-tier lawyers bypassing the line prosecutors, the assistant U.S. attorneys who would normally handle a case like this, and they're going directly to the leadership.
Straight to Acosta.
Straight to Acosta and his top deputies. And they are meeting constantly, secretly. There are no public records of these meetings at the time.
So you have this immense pressure campaign happening behind closed doors, while the victims and their lawyers are being told the investigation is still ongoing.
Correct. Which leads to the central question. Why did it work? Why did Alexander Acosta take that 53-page indictment and effectively tear it up?
This brings us to the intelligence claim. This is probably the most explosive and least verifiable part of the entire story.
It is the ghost in the machine. It's the explanation that hangs over everything, but it's also the one that rests on the thinnest documentary evidence.
We essentially have two competing narratives for why Acosta made the deal he did.
We do. We have the story he allegedly told the Trump transition team when he was being vetted for a cabinet position, and we have the story he told Congress under oath.
Let's start with the first one. This comes from reporting by Vicki Ward in the Daily Beast in July of 2019.
Right. She reported that during his vetting interviews, someone on the transition team asked him about the Epstein deal. What was that all about?
And according to Ward's source, an anonymous source, Acosta's answer was stunning.
It was. He allegedly said, I was told Epstein belonged to intelligence and that the case was above his pay grade.
Belong to intelligence. Such a strange turn of
It's
phrase.
very specific. Not he was a source or he was an asset, but that he belonged to them. It implies ownership.
Now, we have to put a huge asterisk here. This is based on one anonymous source in one news report. There's no transcript of that meeting, no recording.
And that is a critical forensic limitation.
Okay.
We cannot treat it as established fact. We can only note that the allegation exists in the public record.
Especially because Acosta himself has denied it vehemently.
He has. When he was brought before the House Oversight Committee and placed under oath, which is legally binding, he was asked directly.
Did you say that? Did anyone from an intelligence agency contact you?
And his answer was a flat no. He denied ever making the statement. He denied being contacted by any intelligence agency. He denied that intelligence had anything to do with his decision.
So what was his justification under oath? Why did he say he made the deal?
He fell back on the original line. He claimed there were evidentiary concerns. He said he worried that the victims wouldn't be credible witnesses on the stand. He argued that it was better to secure some conviction, even a minor state one, than to risk a full acquittal at a federal trial.
He was trying to salvage something from a weak case. That was his sworn testimony.
That was his official explanation. But it creates this logical inconsistency.
How so?
If the case was truly that weak, if he was so terrified of losing in court, then why was the defense team fighting so hard for such a specific, secretive, and frankly unprecedented deal?
Right. If your opponent's case is about to collapse, you don't offer them a generous settlement. You push it to trial and you humiliate them.
Exactly. The behavior of the defense team hiring star, the private investigators, the constant secret meetings, is the behavior of a team that is terrified of the evidence, not one that thinks the case is weak. Their actions contradict Acosta's justification.
So we're left with an impasse, a reported admission versus a sworn denial.
And our operational rule here has to be that we cannot confirm the intelligence connection based on this. We can't build a theory on it, but we must record the existence of the allegation as part of the total factual matrix surrounding this deal. It's a data point, even if it's a conflicting one.
Okay, so let's move from the why to the how. The mechanism itself, the non-prosecution agreement.
This is the document where the administrative decision becomes legally binding. When you read the actual text of the NPA, it's an extraordinary document.
It's less a punishment and more a business contract, it feels like.
It's an administrative work of art, if your goal is to make a prosecution disappear. Let's break down the key terms.
First, the confinement. He pleads guilty to 2 state charges, not federal ones.
Correct. That keeps him out of the federal prison system, which is a huge win for any defendant. He's sentenced to 18 months total, with 13 months to be served in the Palm Beach County Jail.
But it wasn't really jail in the conventional sense.
Not at all. He was housed in a separate wing. But the most significant provision was work release.
Explain that.
The agreement explicitly allowed Epstein to leave the jail for up to 12 hours a day, 6 days a week, to go to his private office in Palm Beach.
So he was sleeping at the jail, but for all intents and purposes, he was continuing his life and his business during the day.
That's essentially what it amounted to. He could conduct business, meet with people, manage his affairs. It was a form of confinement so lenient as to be almost symbolic.
But as lenient as that was, it's not even the most important part of the NPA, is it?
No. The physical confinement part is window dressing. The real prize, the reason Ken Starr and Alan Dershowitz were in that room, is the immunity clause.
I'm reading the language here from the document. It grants immunity from federal prosecution to Jeffrey Epstein.
Which is standard in a deal like this.
But then it adds a phrase. It extends immunity to any potential co-conspirators.
That's it. That's the clause. That is the forensic anomaly that defines this entire affair.
Any potential co-conspirators. Let's break that down. It doesn't name them.
No names. No list. It's not in these 4 named individuals. It is an open-ended, undefined grant of immunity.
So just to use an analogy, if I'm a getaway driver in a bank robbery and the mastermind gets caught.
Right. And the mastermind wants a deal. The prosecutor's first demand is, give us the driver, give us the safecracker, give us the whole crew. The value you provide in exchange for leniency is your cooperation against your co-conspirators.
I have to give them something.
You have to give them something of value. Here, the deal was the exact opposite. It was, we will give you a lenient deal, and as a bonus, we will promise to never prosecute anyone who worked with you.
Even if we don't know who they are.
Without even asking who they are. It's a level of protection I have never seen in any other NPA. It's a get-out-of-jail-free card not just for Epstein, but for his entire network, for Ghislaine Maxwell, for the recruiters, for the facilitators, for everyone.
So this clause didn't just end the case against Epstein.
It shut down the entire federal investigation into the broader trafficking ring. It legally prevented the FBI from pursuing any of the other leads that came from the evidence.
They couldn't go after the recruiters whose names were on the computers because they had, in advance, been given immunity by this agreement.
They were untouchable. The U.S. Attorney's Office had granted them a prospective pardon. It was a total capitulation.
This is why the weak case argument makes no sense. You don't grant global immunity to an entire criminal network because you're worried about one witness.
You absolutely do not. You do that when the objective is not to win a case, but to contain it, to put a lid on it and stop it from spreading. This clause was designed to kill the investigation, not resolve it.
And to make sure this extraordinary deal couldn't be challenged, they had to take one final illegal step.
This is where it crosses the line from questionable prosecutorial discretion into a clear-cut violation of federal law.
We're talking about the Crime Victims' Rights Act, the CVRA.
Yes, a federal law passed to ensure that victims of crime are not ignored by the justice system. It has very specific requirements.
What does it mandate?
Among other things, it gives victims the right to confer with prosecutors about plea deals and non-prosecution agreements. The government is legally required to inform them and hear them out before a deal is finalized.
They have a right to be in the room, figuratively speaking.
They have a right to be heard. But in this case, they weren't. The documentary record, the court filings from Bradley Edwards, they show a clear timeline.
The NPA was signed and finalized in secret.
Yes. The deal was done, the ink was dry. And only after it was a binding legal document were the victims informed that a deal had been reached.
And it was worse than just not telling them. The records show the U.S. Attorney's Office was actively misleading their lawyers.
That's correct. While these secret negotiations were happening, victims' attorneys were being told that the federal investigation was ongoing and that no decisions had been made.
They were being lied to.
That was the later finding of a federal judge. Judge Kenneth Mira looked at this entire sequence of events and ruled unequivocally that the government had violated the Crime Victims' Rights Act.
And the government eventually admitted it, didn't they?
They had to. The evidence was irrefutable. They eventually conceded that they broke the law in how they handled the notification.
So why? Why the secrecy? Why go to the length of actively deceiving the victims' lawyers?
It was a strategic necessity. If they had followed the law and notified the victims before signing the deal, what would have happened?
The victims' lawyers, like Bradley Edwards, would have immediately gone to court.
They would have filed for an injunction. They would have argued before a judge that this deal was a travesty.
Yeah.
And they would have exposed that secret immunity clause to the light of day.
The deal would have been challenged in public before it could take effect.
And it might not have survived that scrutiny. Secrecy was a functional requirement to lock the deal in place. They had to violate the CVRA to protect the NPA. The illegality was a feature, not a bug.
Okay, let's put all these pieces together. Let's synthesize this chain of events.
It's the only way to see the full picture of the institutional failure.
You start with block one. The evidence, a mountain of it. The file transferred from Palm Beach PD, as documented in Exhibit C, was strong, corroborated, and came with a 53-page roadmap for a federal sex trafficking indictment.
Block two, the opposition. A legal team of unprecedented powers deployed. They engage in an aggressive, high-pressure campaign targeting not just the evidence but the prosecutors themselves.
Block 3. The decision. The U.S. Attorney, Alexander Acosta, claims the case is weak and he needs to negotiate to salvage any conviction at all. This justification is inconsistent with the actions of the defense.
Block 4. The mechanism. The salvage operation results in the MPA, a deal that gives Epstein minimal jail time with work release, but more importantly, provides a blanket of unnamed, unlimited immunity to his entire network of co-conspirators.
And Block 5, the execution. To finalize this deal without challenge, the U.S. Attorney's Office knowingly and illegally conceals it from the victims, violating the Crime Victims' Rights Act.
When you stack those blocks in order, the conclusion is unavoidable. This was not a prosecutorial failure in the sense of a mistake or a lost case. It was a deliberate, negotiated administrative decision to suppress a federal prosecution.
The Palm Beach police did their job.
They did. The FBI agents who got the file were ready to do their jobs. The breakdown happened at the leadership level of the U.S. Attorney's Office.
Acosta was the pivot. He was the one who stood at the gate.
He was the one who took the potential 53-page indictment for sex trafficking and transformed it into an 18-month stay at the county jail with work release. He converted a federal investigation into a SEAL immunity agreement.
And the ultimate why he did it, whether it was the sheer pressure from the defense team, the alleged intelligence connection, or some other factor we don't have documents for, that remains the core unanswered question.
The motivation is the black box. We have the data points, the allegation, the denial. But we can't definitively prove the motive. What we can prove, what is fully documented, is the mechanism. The how is a matter of public record. The NPA exists. The judicial ruling on the CVRA violation exists. The evidence from Exhibit C exists.
And the result of that mechanism was that the entire network was protected for more than a decade.
It bought them 10 years. It stopped the investigation cold in 2008. It meant the recruiters were never questioned, the financiers were never subpoenaed, the clients were never identified. The operation was cauterized.
We've documented the evidence that was there, the legal force that was applied against it, the competing stories for why it was shut down, and the explicit terms of the deal that accomplished it. The official explanation of a weak case is simply not supported by the weight of the evidence.
And that immunity clause for unnamed co-conspirators? It remains the single most significant forensic data point in the entire document. It's the signature. It tells you the goal was not justice for the victims. The goal was containment of the investigation.
This audit shows how the system wasn't just broken. It was actively manipulated to produce a specific outcome. But the story of that outcome, of the deal itself, doesn't end when the NPA was signed. The next chapter is how that deal was actually carried out.
Next time, the sweetheart deal.
You have just heard an analysis of the official record. Every claim, name, and date mentioned in this episode is backed by primary source documents. You can view the original files for yourself at epsteinfiles.fm. If you value this data-first approach to journalism, please leave a 5-star review wherever you're listening right now. It helps keep this investigation visible. We'll see you in the next file.